Welcome back to another video. In my previous videos we were looking at leases and specifically the content requirements of a lease and also the effect leases can have on disponees of land. And in this video we're going to be looking at pretence. So the first section is, can parties opt for a right over land to operate on an in personam basis? Now we've seen this diagram, this picture here in a previous video, but I thought I'd bring it up now so that we can see that the different the different rights and rem that can operate. So we've got like the mortgage, easements, we've got the lease there, freehold, etc. Now, each bubble here has its own set of content requirements in order for that specific right or rem to arise. But the question is, can parties create a right that falls within one of these bubbles, in other words, a proprietary right and rem, but stipulate that the right will operate on an in personam basis instead? That is the question for this first section. The standard position is as follows. In general, parties to a right falling within one of the in rem bubbles can opt for the right to operate on an in personam basis. So we can see an example of that from IDC Group and Clark 1992, which was about an easement. So this seems like the logical position, because if we think about, freedom of contract, you would assume that people should be allowed to determine on what basis their rights operate. So if parties want to have their right to have contractual effect and nothing more, then they should be able to do that. But the position for lease. For a time, the standard position applied equally to leases. The parties to an occupation agreement involving exclusive possession, rent and term could ensure that the agreement would operate in personam by stipulating that it was to take effect as a license. So despite the lease content requirements were satisfied, for a time the standard position had been exactly this, that they could decide on what basis they wish their right to operate. They can have it to operate on an in personam basis. However, in the 1985 case of Street and Mountford, the House of Lords ruled that an arrangement involving exclusive possession, rent and term is necessarily a lease. Okay? Now, I've underlined necessarily because that is subject to a few exceptions. For example, where exclusive possession is, based on charity or friendship or referable to an employment contract between landowner and occupier. But don't worry too much about that. But basically, Street and Mountford sort of moved away from this standard position with regards to leases, and regardless of what the parties choose to describe it, if it fulfills the content requirements of a lease, then it's going to be a lease, regardless if you say, I want this to operate on an in personam basis. And Lord Templeman and Street and Mountford said this: in the present case, the agreement professed an intention by both parties to create a licence, and their belief that they had in fact created a licence, but the consequence in law of the agreement, once concluded, could only be determined by consideration of the effect of the agreement. If the agreement satisfied all the requirements of a tenancy, then the agreement produced a tenancy, and the parties cannot alter the effect of the agreement by insisting that they only created a licence. The manufacture of a 5-pronged implement for manual digging results in a fork, even if the manufacturer, unfamiliar with the English language, insists that he intended to make and has made a spade. And in my previous lectures, I did look at Street and Mountford in considerable depth, so I would recommend you check out those videos about that. And I discussed this quotation from Lord Templeman, and specifically all he's saying essentially is that, even if you've got an agreement that even if it says that you've got a license, but you satisfy all the requirements of a tenancy, then you've got a tenancy, even if you say something to the contrary. Okay, and there's no other way around that. That's what he's trying to say here. And I love that little quote at the end, the quotation at the end where it says, the manufacture of a 5-pronged implement for manual digging results in a fork, even if the manufacturer, unfamiliar with the English language, insists that he intended to make and has made a spade. So if for all intents and purposes you've made one thing, you can't just describe it as another thing and therefore it becomes that other thing. So yeah, I think that all makes sense. So why are leases treated differently? So we've got the standard position, but leases don't follow this same pattern. Why is that the case? Maybe because a leaseholder has access to a lot of statutory protection, which a license holder does not. And otherwise do not have this extensive statutory protection. So maybe this is the reason why the decisions treated Mountford are slightly different. And we're going to look into that now. So the Rent Act. The Rent Act is the collective name for a series of statutes commencing in 1915, which restricts the level of rent that landlords can charge and the circumstances in which they can evict their tenants from residential occupation. The Rent Act regime protects those who occupy pursuant to a lease. It does not protect those who occupy land under license. So what this is saying is that there's a load of Rent Acts, a lot of statutory protection which is afforded to those who have a lease, those who are tenants, and therefore are tenants under a lease. But the Rent Acts will not protect those under a license. So what this could be saying is that effectively, we don't want to just construe leases as licenses and licenses as leases, because there is considerable statutory protection afforded to those who have a lease, and it could lead to some unfortunate and unwanted circumstances if we were to construe it otherwise, despite what the parties may have wanted. So Street and the Rent Acts. The decision in Street was implicitly motivated by a desire that the boundary between those rights protected and those not protected by the Rent Act's legislation be drawn on a principled, substantive basis. Statutory protection afforded to those possessing a right to exclusive possession for a term in return for payment, a lease, and statutory protection denied to those not possessing a right to exclusive possession for a term in return for payment. So this is really what Street and Mountford was. Why that decision by Lord Templeman was come to, and it was all to do with the Rent Act, and because if we can't just be giving statutory protection to people who should only have a license, and we can't be extending or removing the Rent Acts from effective tenant holders by saying that they only have a license. So dodging the Rent Acts. Now, Street is a turning point. From the inception of the Rent Acts, landowners sought to grant occupation rights, falling out the legislation. So landowners were a bit naughty, and they effectively tried to say to their effective tenants that no, you are not a tenant, you're not a leaseholder, because you only have a license. And in effect, they just didn't want to grant those people that were occupying their land to have the protection of the Rent Acts. Okay, it was too much protection for them, and they wanted to establish that what their tenants or landholders had was just a license, so they could remove this protection from the Rent Acts. And now, post Street and Mountford, this could no longer be achieved by the simple expedient of labelling a right to exclusive possession a license. Although the landowners did try to circumvent the Rents Act by calling a lease, what was in effect a lease, a license, that Street and Mountford now makes that impossible to do, because anything that looks like a lease is a lease. So landowners, or more specifically their lawyers, therefore aim to sidestep the Rent Acts by drafting occupation agreements denying the occupant right to exclusive possession. So because they couldn't just dodge the Rent Act by calling them a licensee, they instead tried to sidestep the Rent Act another way, and that was by denying the occupant the right to exclusive possession, which, as we've seen before, is one of the content requirements of a lease. So they tried to just explicitly deny them a legal right in rem by denying them their exclusive possession, which is one of the content requirements of our lease. So, and they did this, or they tried to do this, in 3 separate ways. So, conferring occupation on multiple people, not satisfying the 4 unities. So, as we've seen before, we actually had a look at this section before about exclusive possession in a previous video about how exclusive possession arises and how it can be denied. And one of these ways is by not satisfying the 4 unities when you confer occupation on multiple people, reserving a right to himself as the landowner or a third party to enter into occupation alongside that person, and reserving to himself extensive access for the purpose of cleaning and repairs. Now, I'm not going to talk too much about this because I have mentioned that in my previous videos in a lot more depth, and I did bring it some case law, and I talked about an example using my Blackacre example as well. So if you haven't seen that, I would go check that out. But that is some of the ways that landowners had tried to deny exclusive possession when it comes to giving people occupation of their land, and therefore it's not give them a lease, but rather giving them something else, an in personam right. So that's really an introduction to Pretence. And in the next video, we're going to be looking at the doctrine of Pretence, also known as sham, in a lot more depth, and actually really looking at that specifically. So this was just more of an introduction into why we needed the discussion and what has been the issue and the history of the problem leading up to today in terms of denying people leases and therefore trying to give them in personam rights. But if you have any questions about this video, just leave a comment below and I'll get straight back to you. And make sure you subscribe to my channel because we will be having videos up almost every day. Thank you very much for watching.